Today, we will talk about hold harmless clause, definition, how it's used, and examples. A hold harmless agreement is a legal clause that absolves one party of legal liability for any injuries or damages suffered by another party. A hold harmless agreement is a clause in a legal contract absolving one party of legal liability for any injuries or damages suffered by another party. It ensures that one party cannot hold the other party legally responsible for any risks incurred from services provided. A business may add a hold harmless agreement to a contract, and the service being retained involves risks that the business does not want to be held responsible for legally or financially. A hold harmless agreement is also known as a hold harmless clause or hold harmless provision. Alternatively, it is sometimes called an indemnity agreement. Businesses that offer high-risk activities, such as skydiving sessions, commonly use a hold harmless clause. Although it is not an absolute protection from liability, it indicates that the customer has acknowledged certain risks and agreed to take them. This agreement may be in the form of a letter. The hold harmless agreement may be unilateral or reciprocal. With a unilateral agreement, one party to the contract agrees not to hold the other party liable for injuries or damages incurred. With a reciprocal agreement, both parties to the contract agree to hold the other party harmless. The hold harmless agreement is common in many less obvious situations than a contract for skydiving lessons. An apartment lease may have a hold harmless clause stating that the landlord is not responsible for any damage caused by the tenant. A homeowner hiring a roofer might request a hold harmless agreement to protect against a lawsuit if the roofer falls off the roof. A sports club may include a hold harmless agreement in its contract to prevent its members from suing if they are injured in the course of participating in tennis matches. Contractors often add hold harmless agreements to their contracts to protect their businesses against potential liability arising from their work. A hold harmless agreement does not always protect against lawsuit or liability. Hold harmless agreements that are nebulous in language or overly broad in scope might be disregarded. Moreover, the clause may be deemed null and void if signers present a strong case that they were coerced or beguiled into signing a hold harmless clause. Some states have anti-indemnity regulations limiting or even prohibiting the use of hold harmless clauses within certain professions or under some circumstances, such as residential tenancies. Hold harmless essentially means just that: don't hold me responsible. It appears as an agreement in a contract and when signed should result in the party requesting it being freed from liability for damages or losses. Here are 5 key takeaways. 1. A hold harmless agreement is used to protect a party in a contract from liability for damages or losses. 2. In signing such an agreement, the other party accepts responsibility for certain risks involved in contracting for the service. 3. Hold harmless agreements are more common in business transactions involving dangerous sports, real estate, construction, and other areas where there's a higher risk of loss. 4. A hold harmless agreement does not always protect against lawsuit or liability. 5. These agreements can be disregarded if they are nebulous in language, overly broad in scope, or believed to be fraudulent. Hope this would help. Thanks for watching.